Thank you, Daniela. Hi, everyone. We've got a good lot of delegates, so that's exciting. Okay, so my name's Elspeth, and I'm a partner in the Inquest team at Hempsons, and I'm joined today by Molly, a solicitor in our team. And today we're giving you a bit of a whistle-stop tour about inquests and giving evidence. So just to tell you a bit more about Hempsons, so we are a health and social care law firm. So Molly and I are part of the National Inquests and Inquiries team, and we've got Hempsons as a whole have offices in Manchester, London, Newcastle, Harrogate, Southampton. We travel all over the UK for inquests and inquiries, just so that you know you're in safe hands when I'm giving you all this information today. Our experience, as you can see, it ranges, and there's a few things in there, but sort of hospital-related deaths, mental health inquests, prison deaths. Article 2, homicide, deaths in the community, jury inquests and inquiries. I know that I've had a scout, or we've had a scout of the delegates list. There's a wide-ranging experience and backgrounds of yours, so hopefully we'll touch on things that are pertinent to you. But we also provide bespoke training for the legal teams, governance and clinical leads, and individuals as well. So that's essentially who we are. And how today will work is the first half of it. Molly will take us away and lead on it, and then I will step in for the second half. And then, as Daniela said, questions and answers will be at the end. So, Molly.
Hi everyone, thank you all for joining and Elspeth for starting that off. So just a quick overview of what we're going to cover today. I'm going to go into what is an inquest, just a bit of a broad background for you all, professional obligations, so what you can expect, a little bit on witness statements, giving evidence in court. We'll talk a bit about the findings and conclusions and prevention of future deaths, words you might have heard before but maybe aren't as clear on what they are. And then, as people have mentioned before, we'll come on to a Q&A. So let's get started. So an inquest is a judicial inquiry. It's a factual investigation by a coroner into the deaths of an individual. It's an inquiry to ascertain the facts of an incident, and it is not a method of apportioning blame, but it's just about establishing facts. So the purpose of the coroner is to conduct an investigation to answer 4 questions, which is who died, when they died, where they died, and how they came by their death. And the key question, sort of the main purpose of the inquest, is to answer the question of how that person came by their death. So an inquest is required. It comes from sections 1 and 2 of the Coroners and Justice Act, which applies where a death is violent or unnatural, if the cause of death is unknown, if that person is in custody or in state detention, which can include being under section. I know we've got some of you from some mental health trusts with us today. So examples can be hospital admissions, falls in hospitals, maybe patients who have died from a pressure sore they got in hospital or in a care home, neonatal deaths. But we can also include deaths not involving the NHS. Recent case you might have been aware of, seen in the news, is the really tragic death of Jay Slater. That was sort of widely publicised. But today we'll be focusing on more NHS-related, care home-related inquests. So, moving on to a bit more about when an inquest is required, there's a number of stages to the inquest process. It starts with an initial investigation by the coroner. He'll collate the evidence, he'll receive information from the ME, and he'll make a judgment as to whether that death needs to proceed to a full inquest or with it. The questions can be answered maybe with written information. He will maybe, in certain circumstances, conduct a pre-inquest review hearing, which is where he will consider matters such as if there's any further evidence required, what he already has, any witnesses he's going to need, and he might hear legal submissions from any sort of people who have already been involved or indicated. He will determine who the interested persons are. You might hear people talk about PIPs or IPs, and these are people or bodies, trusts who have the right to actively participate in those inquest proceedings. That could be by the virtue of their relationship to the deceased, or because of their involvement in the circumstances of the death, or because the coroner has the discretion and thinks you might be able to provide sort of helpful, pertinent information. The coroner then will identify the scope of the inquest. What are those key issues, those lines of inquiry or topics that the coroner considers to be relevant to answering those 4 questions we touched on earlier? And of course, those will be case and patient specific. He will then move to the inquest itself, which obviously we'll talk about a little bit more about what to expect sort of throughout the inquest process. So this is a screenshot of what we call the record of inquest, which is essentially the document at the heart of the process and what the coroner has to complete at the end of the inquest. You'll see that the form, if you can see, features those 4 questions. He needs to know who the deceased is, their cause of death, when they died, and then there is that how question, and he will come to a conclusion. And Elspeth is going to take you into conclusions and a bit more on the record of inquest shortly. So the coroner considers how this person came by their death. In a way, it's got to be brief, it's got to be neutral, and got to give a factual account. We touched that it's not it's not a blaming exercise, and that's where this neutral sort of language is really important. He does not consider why the death happens. So just some sort of key takeaways, because I know I whistled through that. To summarise, so an inquest is a judicial inquiry conducted by a coroner, not to apportion blame, but to establish facts, determine the identity of the deceased, when, where and how, sometimes in what circumstances, and that again is one of those topics that could be a webinar all of its own. The purpose of it is to provide transparency, accountability. That's why we have trust, we have police, etc. So the public public awareness, but also there's an ancillary duty that the coroner has that you might have heard of, referred to as Regulation 28 or Prevention of Future Deaths, which is where the coroner sort of looks at anything that happened to this patient and how he can take action or suggest things are done slightly differently, which might save lives of patients in the future. So you've been requested to provide information for an inquest, or you're required to attend the inquest. Your professional obligations will depend on your role, your position, but in general, you have a duty to provide a full and frank disclosure to the court. You must produce or disclose any of those documents within your control, and as it says on the slide, that can be things that are not always helpful to your position, but are relevant to the investigation. You have a duty to the court, and this is something I think we find a lot with our witnesses, and it's sort of making that balance that the duty is to the court. It's not to the parties, it's not to your employer, but you are under oath. We'll talk sort of shortly about statements of truth and how important it is for you to give that evidence to the court. And finally on there, we've got the duty of candour. You might be aware that the new Hillsborough Bill is coming through, and if passed in its current form, that's going to introduce a statutory duty of candour for public authorities and public officials. So something to really keep your eye on there, depending on sort of your role and where you're working. But generally, registered persons must act in an open and transparent way. So moving on to witness statements. Now, one of our lovely colleagues, Misha, will be doing a webinar solely on witness statements across sort of different types, claims, court protection and inquest in a few weeks, so look out for that. But witness statements for inquest specifically, you'll see a lovely little screenshot on the slide, quite old now because we tend not to find people handwrite. We'd be quite surprised if they did, but it does still stand as a good example of sort of what not to do, because it's not great. And as I said, we could spend a long time talking about that, but we like this little screenshot just to sort of give you a bad example before we give you some tips. So a comprehensive witness statement will really help you when giving your evidence. It's that sort of aid memoir that you have in front of you, but it also can avoid the need for you to attend completely if it's, if you include enough information that the coroner doesn't have any further questions to ask you. Some sort of basic tips, headings, paragraphs, subheadings, all really assist. The coroner could say, okay, in paragraph 3, you've said X, Y, Z, it makes your life easier. You've got to include those personal details, your name, your current post, what is your experience, what qualifications have you got? Have you got a GMC or an NMC registration number? And it's very helpful if you tell us you've got a current license to practice as well. we recommend that you outline at the start of your statement anything that you've reviewed to assist you, such as medical records. But also, if you're using things from your memory, do you remember this patient? Do you remember these events? Because it helps us to sort of understand where your perspective is coming from. And then finally, really important to consider, what is the purpose of your evidence? You know, you might get a request from the legal team. What are they asking you for? Is it an overview statement? Is it covering a single appointment or a single procedure? You might be asked to provide assurance or learning information to mitigate a Regulation 28 report, which is something that Elspeth will touch on later in the webinar. But essentially, having that in the back of your mind will guide you and will help you know what is important to put in that statement. So I'm going to hand over to Elspeth now, who's going to talk you through some of these little examples and take you through the rest of the webinar.
Thank you, Molly. That's great. Okay. So these are real examples that we tinkered with, of course, but of two separate statements and circumstances and examples. But you can see sort of the first paragraph at the top, first bullet point, and it says, at some point when entering the deceased room to speak to the medical team regarding a different patient, I noticed Joe Blogg's mean blood pressure was in the 20s. I then was involved a few hours later. So if that paragraph within a statement came to me or others in the legal team, I would have a number of questions. So at some point is quite difficult then for the coroner to understand when you were involved. Now, it might be that the timings are actually in the medical records, in the care records, and are documented. And if so, please put them in. That's great. If it's a case where it's not documented, you checked and you can't remember, then also explain that within the statement. So I cannot remember at what point or at what time I went in, but I say that it was shortly after or at some point within this time frame. But it's essentially giving some kind of parameters, because if in the shoes of the coroner, they are receiving this and they're trying to put everyone's statements in like a massive jigsaw puzzle, and it gets quite confusing when you've got big inquests and a number of different statements, a number of different opinions. So that's sort of one pointer that I'd always say, is put in some time frames, make sure you put in dates. It just keeps it very sort of clean, neat, and very helpful to the coroner. Also in this paragraph, something that I would ask is, or be mindful of, is that people reading this are they may be legally trained, like me, like Molly. The coroner is a lawyer and not a doctor. So it was the case that coroners historically could have been medics or lawyers, and there was a coroner who was both. But they've changed it because it's a legal process. Coroners are actual lawyers and legally trained. So I don't know whether this blood pressure being in the 20s, is that reassuring? Is that alarming? What does that mean to you as a professional? And I'll talk about other examples as well, because I appreciate in sort of mental health settings, you'll have a different frame of reference, and I'll talk about that. But what then helps is if someone actually says whether it's reassuring. Does it show that the treatment's working, as in the trajectory is what you'd hoped for, or is something not working and you need to try something else, or that's what you did? It essentially context, and then you say, or this person said, I then was involved a few hours later. Again, if possible, can we have some actual time frames so that there are some parameters, there's some specifics in this statement, and it will help you later down the line, because quite often, if you then are giving evidence, the medical records will form part of the inquest case and the inquest process, and people will be trying to essentially match up side by side the objective measures within the medical records alongside your statement to show how the patient was faring. So it helps to be as specific as possible. The second paragraph is instantly a lot better and a lot clearer. So they've actually put specifics as to when they've assessed the deceased. They've explained, they've put in specifics in terms of the objective measures and parameters that they were working with and measuring. It also is clear then why things are done. So the adrenaline as an infusion, which is also low considering the blood pressure. So it's actually putting things in context and also explaining why this medic is using adrenaline. What is the purpose for it? What were we trying to achieve? So that's a really helpful paragraph. And I just think, keep in mind that those reading it are not medically trained, including the family. So when you are just saying the mean blood pressure was X, is that good? Is that bad? Is it neutral? What do we actually mean by this? I know that you will know, but others won't. I appreciate we've got a few people on the line from sort of mental health backgrounds and trusts. And in a similar way, it's being specific. If you're doing a mental state examination, you clearly have the different criteria that you're going to be looking at. You're going to be looking at how someone presents, how they speak, how fast or slurred their speech is, whether their behaviour was erratic or not. Please put those in as they are documented clearly, and then say the relevance of it as to whether that was reassuring, whether the protective factors were mentioned, whether there was just ideation but no plan, etc. And so it's just being specific as possible to assist the coroner. And as Molly said, the more information and detail that you can provide in these statements to reduce the number of questions can actually not only help you at the inquest, but it may prevent the need for you attending the inquest in the first place, which I know everyone is, that's the pinnacle. That's what people want, is to be told that their statement's enough and that they're not then required. So, statement of truth. At the end of your witness statement, you will be, so the legal team, if you're putting one in, will likely add in this statement of truth, or if it's not, or a form of words that is essentially you're attesting to swear by this and this is the truth. This may be within your precedents that the organisations sort of provide quite often. There's templates that can be used, and then you fill in the juicy bit, the actual detail of it, and then there's statement of truth. I think sometimes because templates are put out, headers, footers, statements of truth are maybe not considered with the gravitas that possibly you'd want. And I understand everyone's extremely busy and you're just completing the statement as best you can. But if you read the words, you are saying that the facts stated are true, or you believe them to be true. Now, for me, if I were preparing a statement, this would either be, I could sign that because I've looked at the actual records, I've looked at the care notes, I've looked at the electronic record or written record, or if there's not those, I've really thought about it and done the best I can with my recollection so that I can stand by that statement and sign that statement of truth. Even if you are not going to an inquest, I really want to impress upon anyone here, if you are giving a statement and writing a statement and signing off a statement of truth, you need to be prepared to go to court and swear that that is still either accurate, or there are occasions where you can say, I've now seen an error or a typo, or I've noted this additional note, and we can, that's sort of by the by, and that can be addressed. But as best as possible, this shouldn't be done. I would not want to see, and legal teams do not want to see, a statement where someone has put, maybe at the start, I've not had a chance to review the records. This is what I'm saying. Well, if you've not had a chance to review the records and the records exist, then you should not be signing off a statement. You need to be taking this seriously. And I impress it upon you because it's for your own benefit later down the line, because this is a statement that you're attesting to the court. It's a legal document and a court document. So I know I'm going a bit heavy, I'm going a bit pedantic and lawyery on you, but it's important to convey that to everyone. Moving on to the key takeaways then about all the statements. Check dates, check times, and check your spelling. Proofread it. I also do appreciate that often people are doing this outside of their usual role and their working hours, and they're tired and it's a lot, and it can also be, and I don't think we've not mentioned it, but it's not that I don't think it's important, but it's extremely emotionally draining, especially if you've been involved with that patient and then you find out that they've passed away. That is distressing, and we do appreciate that, and so doing these statements is quite challenging on multiple levels. But proofread it. Things that I've seen before, and luckily sort of our team are alert to them so can spot them before they go to inquest. But I've seen the wrong deceased name be in a statement, and that will be undoubtedly because someone is overwriting, and that's my second point, an already completed statement. That's sort of unforgivable, and so I'm going hard on you, but it's something that could be easily done, because especially when you see the templates of statements, you might just sort of look really quickly at the start bit. I am Joe Bloggs, this is my profession, this is my job title, I'm writing in relation to the inquest of. You might just think that's all a given, and then you really take your time with the rest of the detail. But we have seen it, and so I flag, because it totally undermines the credibility, and of course it's very distressing for family. Dates of death being incorrect, or dates of admission being incorrect, that's also unfortunate, but again, things that can happen, and so we look out for it as sort of the legal teams, but also being mindful of these pitfalls as well. I think it's important, as Molly set out before, you have a duty to your profession, you have a duty to the court, and so if there are any errors, missed opportunities, they can be flagged. There's no party line to set out, so you can say that this was a missed opportunity, because then the legal team will be aware of it and it will be part of an investigation, for instance. What is quite challenging is if something's not been addressed that will clearly end up coming out in the wash at the inquest. And then the question is, well, why has that not been set out in the statement? Now, if you don't feel comfortable and it's not within your role and expertise, then of course it's not within your expertise, so you don't need to discuss it. But I think if it's something that you know about, then it should be flagged and should be flagged to the legal team, and then that can be set out. I also think people tend to forget to set out good practice. I think we are very focused on, quite naturally, why someone has come by their death, and I understand that, of course, and that is the most important thing. But also, if there's good practice, please set it out, because the coroner needs to be aware of that, as do the family. Point 4, keep within your expertise, do not speculate. If you are a mental health practitioner and there is something to do with the physical health, we do not expect you to comment on it. You do not need to, and vice versa. I think the point to make is you can signpost. So if there is something that is outside of your expertise, we've seen in statements before, and it's been very helpful to say, and if the coroner has questions, glad to assist. If the coroner has questions, and this can be written in the statement, if the coroner has further questions regarding surgical input, I direct them to the surgical consultant who was undertaking that procedure, for instance. You can do that. the part that you may be within your gift would be clearly the, I'm just using example, but if you were on a ward and there's escalations to the surgical team, or there are discussions in the surgical team, then that is within your gift, that's within your knowledge and within your expertise. But talking about specifics as to the procedure undertaken may not be within your expertise. And so it's important to, again, frame your evidence so it's very clear the involvement that you had. Equally, it's important to set out, and again, it's helpful with headings, but if you were not involved until X date, then you can make that clear in your statement. So you could say patient X was admitted from this date to this date. I became involved on X date, but I was aware of the admission, or it was handed over to me, XYZ, and you can make that clear as well. Point 5, when including medical observations, provide context. I use that example in the example, sorry, of the witness statements. I think it's important to be able to say whether something is reassuring or not. Avoid acronyms and jargon. So I've used an example of a previous case I was in. Now, we being coroner and all the interested persons of the organisations involved, a proposed cause of death. And you'll see at point 2, which is factors that are not directly contributing to death, but not the direct cause of death, but have contributed to the death in some way. So the past medical or background medical history. And there's lots of acronyms there. Most of them are generic. AF, atrial fibrillation, we understand that. But interestingly, this exact thing happened where the coroner said, and I won't say which coroner it was because it did baffle me a little bit. But when she was reading it, she said LTC, long-term condition. And I was thinking, well, I definitely don't think that's actually what was meant there. But the statement had not elaborated, had not converted these the shorthand essentially into longhand. So my questions then to later witnesses was, is it long-term condition or is it likely to be long-term catheter? And they confirm long-term catheter. And I know it's a silly example, but it just shows that things can be misunderstood at an inquest if you assume understanding. So don't do that. Point 7, check the medical records, care records. Do not rely purely on your memory. However, there are occasions where it will just be on memory that you can comment. That's fine. Just make clear in your statement that this is what I recall. Because as we know, documentation is king. So in terms of the coroner will be looking first at the records, see what was written down, and then secondly, what can you remember? Point 8, do not repeat verbatim what's in the notes, expand and clarify. This is just showing the example. We've had cases before where people have essentially copied and pasted the notes, but provided zero explanation. That's also not helpful because the coroner is not seeking the statement from you just for you to copy and paste the notes, which the coroner will have already. They want your expertise and your knowledge to be applied to those notes to provide the context and so that we understand. So I'm not saying that you can't copy and paste some notes, but if you were going to, add the detail, add the explanation, understand the bigger picture. So this is part of your preparation for the witness statements. So I would, as part of my preparations, I would always review the medical cause of death so that we can understand the basis for why the coroner is seeking your statement, or look at the post-mortem. Have a look if there have been trust investigations or reports, rapid reviews, mortality reviews, or larger PSI investigations, so that you appreciate what the focus and the themes are going to be. And also, if you haven't received, or the trust hasn't received from the coroner, a family statement, so it's ordinarily the coroners will ask families to produce a statement, and in that statement, often families will list the questions that they have. Sometimes we don't get that, sometimes we do, but also just check if there's been any past complaints, so we can understand where is it that the family are just not understanding or appreciating certain points. Keep to the facts and professional opinions. This point 10. Avoid personal commentary and criticism of colleagues. Just keep it factual neutral, because colleagues, if there is something to explain about their role, then they can provide their own statement, and that's a matter for them. Your role is to talk about what you did and what you know about and what's within your experience and skill level. Okay, so giving evidence, right? So you've done your statement, you've handed it in. Prepare that it could be a number of months before you're contacted again. I know that's not a nice feeling. People like to know that that's done and dusted. It's just the way it is. So coroners probably list things, in my experience, if it's 3 days or more, it will be a good, what, Molly, would you say 6 months?
Yeah, minimum.
Minimum 6 months in the diary before the coroner's sort of asking for statements. If it's longer and there's more statements, more individuals, it could be a lot longer. It can, be more sort of 9 months or a year. So it's a long process. So you have to just bear with it. So that's why produce your statement based on, and prepare as best as possible based on the information that you have at that point. And if you set out in your statement what information you've relied upon, then it's clear. If there's additional information that came out, then you can look at either an addendum statement, or you know where your statement was in the sort of life process of the inquest. Okay, so you've given a statement, and then someone said an inquest has been listed and the coroner has called you to give evidence. The coroner has a wide discretion to request an individual to attend, so they can, their discretion is a wide discretion is to produce a witness statement or report, produce relevant documents within your control, and attend the inquest then off the back of those documents or your statement or your report to give evidence. I want to just chip in here that please don't be alarmed if you are called to give evidence. It's not necessarily at all because your statement wasn't the most detailed as possible and is really, really helpful. But everyone in the process needs to agree if something is going to remain as a document that is read into the record, and so there are no questions relating to it, or if someone's called to the inquest. Wait. There we go. So please don't be alarmed, but that's the way it is you've been called to the inquest off the back of a statement or report. So it is possible to go back to a coroner and say, you've asked for patient X, you've asked for witness 1. However, looking at the family's questions, looking at the scope of your inquest, looking at the post-mortem report, this person may not be of most assistance to you. A second person may be more appropriate. Submissions can be made, but we'll go back to entirely the coroner's discretion. So they could say, well, no, I want them both, or I want one, or and just say that, and we just have to deal with that because it's the coroner's investigation. Attendance is usually requested informally, but a witness summons can be used. So what this means in basic language is that a coroner will contact your organisation. So either if you have a legal team or governance team, or whoever's been liaising with the coroner, or can contact an individual, they can contact a witness directly. And they can say the inquest is listed on X date, and you are required to attend. At that point, if you have not been told of the inquest date before then, and so you already had a pre-booked holiday, I don't know, a huge event, a wedding or a medical appointment that couldn't be moved, then again, representations can be made to say you are not able to attend on that day, but they have to be for pretty good reason, and it cannot be a case of it's just not convenient for you. So essentially, when you see an email come in, please respond to it, please act on it, note it in your diary, don't ignore it, because that's when it becomes more difficult for you. If someone refuses and just says I'm not coming, they can issue a witness summons. No one wants that, because it could be a fine. Technically, it could be some time in custody. I have not experienced that. I think that's extremely rare, so rare that it's not within my sort of practice areas to what we've experienced before, but it is possible. So just be mindful, if you're called to give evidence, be prepared to book that time off, and be ready for the inquest. Okay, what to expect during an inquest. Inquests mostly are in person and will be held in person, but they can be remote again if for some reason. So another example, you've been called to the inquest, and you have you've actually moved, you're now in Scotland, and this will be hours and hours of driving for quite a short attendance. You can ask the court if it's possible, you can give evidence over Teams. But again, it's the court discretion in relation to that. I think the default position is in person. I haven't touched, or we haven't touched today on Article 2 inquests or jury inquests, because that's a whole nother session in itself. But coroners courts can have jury empanelment. Coroners courts are public courts, and so the press can attend. They can't take pictures in court, they can't record things in court, but they can write what you say, they can write your name, and they can take pictures as you leave court, for instance, and that's within their right. The coroner will take you through your statement and ask questions, and then the interested persons will ask questions. So what this means is that the family have an opportunity to ask questions, and then say your organisation, if they're an interested person, can ask questions at the end. You're able to bring support with you, and we often get asked, what do you do if you do not know the answer? Well, I suppose it's two parts to this. Should you know the answer? Because should this be something that's within your expertise, experience, and based on the medical records? But if it's not within your expertise and you don't know because it's not in the records, and you may have provided an overarching statement and you don't know why that person did X, Y, Z, and you've tried to find out and you do not know the reason, then just say that is evidence in itself. Okay, takeaways. Check time, check location of the inquest. Review your notes and records and your statements. Don't read it the morning of, read it before. And I recommend reading it out aloud, because there's something different. It stays in your brain more if you read it out aloud, either to yourself or to a family member who allows you to do that. Dress smartly, of course. If attending remotely, giving evidence over Teams, then test your connection. Make sure it's a private location. No one's going to be in, out, check that you've blurred your background so there's no patient details or individual details behind you. Do not guess. If there is a question and the answer is within your statement, you can say, oh, bear with me, I'm just going to check my statement. That's also absolutely fine. You do not need to fill the silence. If the coroner's asked a question and you've answered it, just wait for the next question. And again, your duty is to tell the truth to the court, best of your ability. There is no party line to hold. Outcomes and conclusions, and I realise I'm going to speed up because I've been chatting away. So your legal team or your representative will make legal submissions to the coroner. So after all the evidence has been heard, submissions will be made on what conclusions the coroner can safely return. The coroner will then have some time and then return and make findings of fact. They are making findings on the balance of probabilities, so whether something's more likely than not to be the case. So it is not a criminal standard. It does not need to be beyond reasonable doubt. It's a civil standard. Conclusions you may have seen before are natural causes, accident, misadventure, suicide, unlawful killing, or a narrative, which is rather than a short form, such as natural causes, it's a brief paragraph, few sentences of brief language, and I'll show you some examples now. So this is an example. So the conclusion is natural causes. The box 3 is the how, the when, the where the person, the individual died. So this is an example of a natural causes conclusion, or the findings that led to a natural causes conclusion. This on screen now is a narrative conclusion. Now you'll see here the coroner has added there was a failure to prescribe oral antibiotics which contributed to death. So to be able to include that in the conclusion, the coroner had to have found on balance of probabilities that there was a failure, and it was more likely than not that it probably contributed to death. It's important to know as well, the contribution to death is also the contribution to the time of death. So if it's hastened death in a material way, that is a causal link between the act or the omission and the death. So just to add that in. Okay, so just to add, I know not all people on the delegates have GMC or NMC obligations, but I just wanted to flag, if you are a registrant, of course, and under those regulators, then you do have a duty to participate and actively participate in formal inquiries, and these include inquests. And again, for the NMC, you have a duty to any sort of court or formal investigation. You have a duty to participate and assist as best as you can. Okay, key takeaways. The findings, because this is not apportioning blame, it's brief, neutral language. That is not to say that the coroner won't find omissions or acts that contributed to the death, but it will still be in brief and neutral language. They record matters that probably caused the death. In Article 2 inquest, which again is a whole other topic, but the scope's widened so they can include things that possibly cause the death. So the level is essentially dropped, or the scope is widened on possible rather than probable contributory factors. The record of inquest, which is that Form 2 that Molly showed earlier, that is a public document, and of course the whole court hearing is open to the press, open to members of the public. They can just sit and listen. So it's a public court process. The findings are not binding on civil and criminal courts, but they can indicate the success of a claim thereafter. So of course, in the previous conclusion where the failure in relation to the antibiotics contributed to the death, that will then likely be something that the claimants will use as a basis for a subsequent claim to be considered. So it's not binding, but it is indicative. It can have reputational impacts, of course, because even though it's brief, neutral language, if the coroner identifies failures or missed opportunities, then of course that can have the impact. And if the press are there, then they can report quite fairly. And again, it is emotionally draining, emotionally challenging, and we do understand. So although you're going in a professional capacity, you do have to look after yourself, your well-being as well, and your team will be around you to support you in that process as well. Okay, prevention of future deaths. So the coroner has two hats. One hat is, of course, identifying the who died, when they died, where they died, and how they died. But the second hat is if anything revealed in the coroner's investigation gives rise to a concern that circumstances creating a risk of other deaths will occur or continue to exist, they can issue a prevention of future deaths report, otherwise known as the Regulation 28 report. The purpose of it is to improve public health, welfare and safety. If issued, so this is it's a public document, so it's I've put the links to the link there to PFDs and responses. So it goes to an organisation where the coroner says, I'm concerned, and then the organisation has 56 days to respond to that, and both the PFD and the response is publicly available and is also used as part of just more national learning. I know that we have a few delegates who are from governance teams who might be keen on this, and we can do training and bespoke information about this, but how do you reduce the risk of PFDs? If there's an investigation, there's often findings. If there's findings, there's often learnings and actions. Make sure when whoever is giving evidence to the coroner about actions that we try and complete and confirm completion of as many actions as possible, and give evidence to that. So check, have the actions been completed, and do we have evidence to prove that they've been completed? Do we have audits to show whether this learning has been embedded and things are improving? Because that's the cherry on the cake, really. And also be mindful, is this a local issue or is it a national concern? Make sure that the coroner is aware if it's a national concern and actually we're following national guidance, but the coroner may be concerned about the quality of that national guidance, or if there's no national guidance, then the coroner needs to be aware of where to direct this PFD. Okay. We have created an inquest handbook, which is this in a nutshell. So you can scan this or follow the link afterwards that will be sent out and download that handbook, and you can read it, disseminate it to colleagues and staff as you wish. And then we've got 2 questions.
Yeah, so generally, a registered person or a registered provider will be someone who is under sort of the GMC. For example, as a solicitor, we are regulated by the Solicitors Regulatory Authority. So if you have a regulator who you sort of sign up to, you pay to, and they monitor your conduct, that would be a registered person. Organisations like the NHS, individual trusts, private care homes who are registered with the CQC, they would also be registered. In terms of Hillsborough, obviously things are a bit more up in the air because that bill is still going through Parliament, and we're not sure how much is going to change, although the key thing is that they don't want it to change too much. But that will widen, and it'll be a statutory duty, which means sort of embedded in the law. And we sort of as a firm will be keeping a close eye on that and how that statutory duty applies to professionals and bodies, because it looks like that it will apply to you as NHS professionals and things like that. So it'll be a case of monitoring that and how that applies to your regulations. So also keep an eye on sort of your NMC and your GMC websites. I realise that was quite a long answer, but essentially, if you're a regulated profession.
Yeah, exactly. If you're regulated by CQC, then you'll fall under registered person, refers to registered manager or registered provider of these sort of health and social care services. But you also, of course, have duties as professionals to act in a way that's open, transparent. So it's sort of that there's multiple levels, but we can obviously provide further information after this if you want specifics as to how that applies to you and your organisation.
Yeah, good.
Okay. I feel your pain. Whoever asked that question. It is unfortunate, but it does happen. And I think so in answer, you asked, can a conversation be had? So conversations can be had in advance, and no doubt were had for someone to have been stood down initially. The difficulty comes when or if, because as I said earlier, for someone to be stood down and their evidence to be read into the record and them not needing to attend, that means that all the relevant interested persons, which include the family, don't have any questions. And sometimes families will review the bundle and then think, no, I do have this question. Now, there are sometimes ways to get around it, where we can say, your representative could say, we are desperately struggling with rota issues, we have no one to, and it's a public patient safety issue. And of course, we can make those representations. We could also sometimes offer and say, if there are additional questions or a distinct issue that needs to be addressed, then we could draft an addendum statement to address that issue. There are sometimes ways and means, but also sometimes unfortunately, it's a matter of supporting your staff member, which I appreciate, that's incredibly stressful. But if we step into the coroner's shoes, the alternative is that the inquest doesn't go ahead and we wait another 6-9 months, which is devastating for the witnesses who are already called, but also family. So I understand your pain, and it is a bit of a balance. I certainly, one inquest that we've had recently, I've emailed the court and said, I didn't say I need, I wouldn't be so precocious, but I say ideally we need 6 weeks notice to arrange the rotas, and they did get themselves in gear and provide us a running order so that we could manage the staff and the expectations. The difficulty in that situation, it sounds, is that because this individual was stood down, something's changed in a very quick instance that has flipped that from them being stood down to being called, and that's the difficulty. So conversations can be had, but the coroner's also wanting to avoid adjourning an inquest as best as possible. I hope that answers the question.
So it means prevention of future deaths. It's one of those habits, I think, that as a lawyer you slip into, and we say PFD and we also say Reg 28. So there's sort of an interchangeable term for the same duty that the coroner has, but it means prevention of future deaths, which is the report that the coroner writes if he's got concerns.
So, ordinarily, no, you're unlikely to be required the whole 9 days. What I think may have happened in this situation is that the coroner won't have determined on which day you are due to give evidence. So until they determine that, they have to just warn people for the full 9 days, because otherwise it's like herding cats. So they will say, block this time out. If within that 9 days that you then write back and say, I cannot do XYZ days, then you can make the coroner aware of this and they'll do what they can to jiggle the running order. So no, you won't be ordinarily there for 9 days. You certainly won't be giving evidence for 9 days. The only caveat I have is that sometimes in cases, if you are giving evidence regarding an investigation or learning, I would, if possible, encourage you to be there for the entirety of the evidence, because learning sometimes comes out in the wash during the inquest, and so your presence is needed. And the fact that you're no longer working for that organisation, again, the coroner can call anyone, any witness that. So we do have it in situations where someone no longer works for that organisation. I appreciate it makes things a bit difficult, but as long as you inform your current organisation as to the requirements so that they can help negotiate your sort of shift pattern or whatever. But yes, short answer, not for all 9 days, but until they tell you what day, you need to kind of block that out in your diary.